Doritos is already one of the most popular snacks on the planet, so to increase sales for 2010, we decided to make them more than just a snack.
Kind of a commercial, but more of an augmented reality.
Hello. I'm sorry I couldn't be with you in person, but thank you for the opportunity to speak to you for a few minutes about the very first legal action to be filed having to do with augmented reality. Now, for those of you who don't know, my name is Brian Wassom. I am an attorney practicing out of Detroit, Michigan. I do represent some augmented reality clients, and I also blog at augmentedlegality.com about the law that governs the augmented reality industry. Now, obviously, I care about this. I'm a lawyer. Law is what I do. And I've been thinking and talking and writing about this particular moment in time for years now. But why should you care about litigation over a bag of Doritos? Well, put yourself in this story. Put yourself in the shoes of the CEO or entrepreneur behind a small augmented reality startup company. Let's say you've been at it for a while now and you have a great idea, great business plan. You could really be the next big thing. All you need is the right investor or the right business client to adopt your product and use it to sell theirs. You know the challenges. You've been to the AR conferences, you've heard the stories, and you know that the whole industry is just about to break into the mainstream, but there's still that barrier there, that barrier of persuasion and adoption before the public and businesses really seize hold of this technology. So you walk into this meeting, this pitch with a potential client armed with all the statistics. You show them cool concept videos. You give them information about Lego kiosks and the number of layer downloads on cell phones, and all ready to convince them that you can be the next big thing, that this is the technology that they want to adopt to sell their product line. And 5 minutes into your pitch, you think it's going well, and the businessman stops you and he says, "I've heard all about this augmented stuff. I don't want to get sued. I don't want to adopt that technology." Why would that happen? Well, first let me tell you a little bit about the case itself and the specifics of what's being alleged. The complaint was filed on October 19th of this year, so just a couple weeks ago. The filers were 4 different consumer watchdog groups. The subject matter of the complaint has to do with the Doritos brand, and specifically the series of social media and AR tools that were used to advertise the Doritos late night brand. What's wrong with that, you might ask? Well, that's a good question. But what these consumer watchdogs have a problem with is basically new technology being used to sell fatty foods to teenagers. And because this new technology is being used to sell these snacks, they're attacking the new technology. The problem for the industry comes in how these plaintiffs have made their argument. See, they don't attack just this campaign. They don't attack the idea of holding a marker up to a webcam. They attack the idea of augmented reality itself. For example, they say that augmented reality, online gaming, virtual environments, and other immersive techniques distract the conscious attention of teenagers and foster impulsive behaviors. As you and I both know, AR is not the only immersive media out there. There are video games that have existed for decades that can really suck you in and cause you to lose track of time, everything else. But they single out here augmented reality as an immersive technique that draws in teenagers. And they offer a lot of social science behind it for how the teenage brain is unable to cope with these immersive media and how they get uniquely distracted from what they're doing and what they're thinking about, to the point where allegedly they don't even realize that they're looking at advertising anymore, and they're basically hypnotized into buying these Dorito chips. Now, there are a lot of problems with this argument, but at the same time, we can't deny that AR is a very immersive technology. That's what makes AR AR. Without some level of immersion, we don't accept the digital data as part of our physical three-dimensional landscape. And without that mental acceptance, AR really doesn't accomplish what it sets out to accomplish. We also can't deny that using AR is an effective marketing strategy. If it weren't, we wouldn't be out there selling these tools to our potential clients. So you can see how defending against an accusation like this is going to take as much PR and social science skill as it will legal prowess. Well, just so you can understand what's going to happen procedurally with this complaint, let me explain a little bit about it. This complaint was filed with the Federal Trade Commission, or FTC, which is not a court, it's an administrative body. The FTC, now that it's received this complaint, it doesn't have a legal obligation to do anything. It could just let it sit there. If the FTC does choose to act, it really has two options. The first is to file an actual lawsuit where now the FTC becomes the plaintiff, and the FTC would sue PepsiCo, Frito-Lay, whoever else in an actual federal court. The second choice is to pursue an administrative action inside the FTC itself. Now, this looks a lot like a lawsuit. The FTC would again file a complaint against PepsiCo, whoever else, and PepsiCo would get a chance to come in and respond. And in either situation, people like the consumer watchdog groups who filed this complaint in the first place would also get the chance to come in, intervene as parties, offer testimony. In either case, the FTC can pursue a cease and desist or an injunction order that would prevent the marketer from using these techniques in the future. The only difference is that in the administrative proceeding, monetary damages would not be available. In either case, whether the FTC files a federal lawsuit or an administrative proceeding, if the defendant loses that case, it can be appealed up to a U.S. Court of Appeals. So we're talking about long-term litigation if this goes the distance. What danger does this legal action pose to your company? In that very lawsuit, they don't just talk about the Doritos campaign. There's a section of it dedicated to other deceptive uses of immersive technologies, and the representatives of these watchdog groups have been quoted as saying, "We intend to file more lawsuits like this within the next year." Indirectly, what this campaign means for you is that it threatens to set not only a legal precedent when it comes to the use of AR in marketing, but also a perception. The phrase augmented reality has now already been associated with the word deceptive, and that's an association that we as an industry need to break. I'll end with a few takeaways. What is it that I want you to take away from this discussion? Well, first, be aware. Be aware that this argument is out there. That's not going to go away. Whatever happens with this particular legal action, if it fizzles out early or if it goes in a different direction, the issue is out there now, and somebody else is going to come back and make it against another company with another AR campaign. My next takeaway is this: don't be too dismissive of the arguments that these groups are making in lawsuits like this. Now, whether you think it's persuasive in the case of Doritos or not, the fact is, immersive technologies are powerful. They do have the ability to suck people in. And whether that is appropriate or not in every single given context, we can't say in generalities. So, yeah, don't abandon the technology, but do take the risks seriously. And think ahead of time of whether this particular campaign is maybe a little too immersive, or maybe there's something different you can do with it to head off some of these arguments ahead of time. And finally, most obvious, get sound legal advice. But whether you get your legal advice from me or someone else, the important thing is that the AR industry as a whole needs to come up with a powerful counter-narrative to the arguments that these watchdog groups are making. You never get a second chance to make a first impression. The AR industry is at the point in history where it's making its first impression right now on the hearts and the minds of businesses and the consuming public across the country and across the world. Let's make sure it's the right one. Well, that's all for this video presentation. Again, thank you for listening. Thank you for the chance to present on this topic to you. You can find me online at wassom.com, W-A-S-S-O-M, or augmentedlegality.com. My email address is bdw@honigman, HONIGMAN.com, or find me on Twitter at bdwassom. Thanks.